What's up, everybody? Welcome back into an episode of the Lawyer You Know podcast. And today we are bringing you another Donna Adelson update post verdict to get my dad's reaction to the defense's case in chief, the closing arguments, the verdict itself, and then what happens after the verdict. Do we see any issues that are ripe for appeal that happened throughout this trial? We're going to get his take. We're going to get his answers on all the questions you had throughout this entire trial. So make sure you guys hit the like button and let's get to it. All right, so we have some finality, at least in Donna Adelson's case. Is it over? We'll talk about that as we go throughout the episode here with this entire saga. But from a lawyer's perspective, which is what we bring to this entire genre and this case and these discussions, I did think it was important to still recap the defense's case in chief. Think about what are they thinking? Why are they calling these witnesses? Now, I know we have the verdict, and sometimes the defense's case in chief can seem like ages ago. We know that they lost. So does that automatically mean that they sucked because they lost? We're going to get into all that, but I think the best way to do it would be to start out by recapping and discussing their witnesses. Why did they call these witnesses? Did you think it was effective or not effective? You can highlight the points that you think were either highlights or lowlights throughout the defense's case in chief to really build on what did they make the jury think about when they went back to deliberate about this case.
Well, generally speaking, there were some witnesses that may have had some meat, but they put on a lot of witnesses that really didn't have a lot of meat that was going to really affect the jury. It might, a lawyer looking at it might be affected by it, but the man sitting on the jury, the woman sitting on the jury, I don't think it affects them. For instance, putting on best friends to say that you're going to hurt yourself or that you needed to get away. That didn't have any impact on guilt or innocence in this case. So Pam Cunningham, she testified, and I don't think that I frankly think it was a kind of a waste of time to put her on. Her life partner, they put them on, but the life partner, basically his quote was, "That's what friends are for. That whatever you need, we will be there." Statements like that. How does that help you? How does that give credibility to that witness?
Yeah, I thought Georgia Kaplan was going to talk about that in her closing. Like the witnesses they put up there are literally witnesses that would do anything for their best friends because that's what friends are for, and put the quote up. I mean, I thought they got up there and said all the stuff you want to say. She's nice. They're a common or normal Jewish grandmother, which then gets smashed in the face with Donna Adelson's emails, which is not normal for any grandmother to say some of the things that she was willing to say, even in a maybe contentious custody battle, maybe not. We'll get to that later with the other witnesses. But generally speaking, as lawyers, we think we've got to put some good stuff out there about our client. That's what they did with these witnesses. But as far as it goes to a jury, I'm not so sure it was effective either. I agree with you that it felt like they were putting up witnesses just to put up witnesses to make it seem like, look, we have a case too. We have witnesses, we have evidence, but a lot of it was not incredibly effective.
All right. Well, I mean, listen to never. This is what Ms. Cunningham said. She never called Dan names. She doesn't recall ever hearing about a bribe. She doesn't recall hearing about extortion. How do you not recall hearing about extortion? And the jury got it wrong in Charlie's case. So, again, no help.
Yeah, there's just so many negatives that, again, if you're going to call a witness like that, you have to be careful. And I think the state did a good job crossing her and pointing out that she's biased, which doesn't mean she's not credible, right? But bias is always a part of what we do in cross-examination. And the state highlighted, you're her best friend, so you want to come help her. And then number two, that she doesn't really know a lot of the important facts in this case because you don't tell your friends if you're going to do something like this, right? I mean, I think that's another key factor the state pointed out through these witnesses.
Next, they put on a digital expert. So they put on a digital expert. Digital expert testified that the tower closest to Charlie's house did not reflect the key phone call. I'm outside your house. However, we all know that it's the tower that on each side of Charlie's house that did reflect that phone call, not the one that was the closest to Charlie's house. So the state put on digital evidence that she was in that area, just not in the tower that was closest. But then the key phrase was from Cross that this digital witness did not disagree with the state's witness, Corbett. So why do you put somebody on that's not going to disagree with the state's witness? But they did. So again, that was a waste of time for them.
So it was a text message, the I'm outside your house, which was another factor they got, that we don't get times, or we don't get location stamps from text messages. So you had their witness confirm that we didn't get a location stamp for we're outside your house. And the calls, you're right. She said she didn't disagree with Corbett, which totally smashed any relevance she would have to that portion. I thought the only, maybe good thing she did for the defense was say each one of these calls has multiple entries on this list, so it looks like more calls than it actually was. Now, how probative is that? I don't really know.
Well, she also said, and she did testify, that it was no big deal, that the number of calls. So again, I think that killed her effectiveness. So again, that's something I really don't think that they got really any points out of that. And then they brought the best friend who's Cunningham back to ask her about the phone records, and she talked about WhatsApp, and the prosecutor then said, "Well, WhatsApp didn't do voice calls on July. I guess July 18th was the date they were talking about." But again, going back to how effective the defense was, how did they let the prosecutor put into evidence that WhatsApp did not do voice calls on July 18th? There was no testimony to that. There was no evidence of that. The state didn't put that on in their case. Their expert did not testify to that, but there was no objection. So, and this is kind of a theme through the case, where they let the prosecutor bring in a fact or cross-examine on a fact and not object to it. And that's a key example there. There's a key fact that they made this woman look bad because they said about the WhatsApp, and she did look bad because of that. But yet they didn't object to it.
You're right. That was a really common thing in cross, and people don't get when lawyers object facts not in evidence during a question. They're expecting it's always the answer is going to be facts not in evidence, but no, the answer will become evidence. So that's how facts become evidence. But in the lawyer's questions, if I say things like Tallahassee, it never gets below 50 degrees, so that's impossible. It's like, well, you can't just say that. You have to have some backing for that. There's got to be some fact that you're pulling from, or at least a reasonable basis from that. And you're right. She did that multiple times with, certain definitions of words. What does this mean? They mean this when they say it, when nobody actually testified to that. You can ask, did they mean this when they said that? Is this what you mean when you were speaking in code? Or is this what you meant by a name you were calling somebody? But to me, she did that multiple times in leading questions when it was her witness, and then putting facts not in evidence in her cross-examination questions that the defense did not nip in the bud, did not hold her accountable for, or put her in a corner and make sure you can only play by the rules. And that's another reason why the prosecutors were just allowed to just run through this courtroom. They dominated this courtroom, and the defense attorneys were the ones sitting over there. I don't know if they were too afraid or didn't know to object, but they missed so many opportunities to object throughout this entire trial, which is a problem when it comes to a proper record in this case.
Right. And so I said, that really stood out to me, that she was able to throw that fact in, make their witness look terrible, and they were just sitting there on their hands. So,
what did you think about Richard Chagrin, the travel expert who had been to 75 countries? I feel like that's a guy you would hang out with.
I got to be honest with you, I liked him. He was the one defense witness that really had some meat. He really went directly to one of the bad issues, or one of the bad facts for the defense, and that was this Vietnam trip. I think they could have used him more, maybe better, but he was important. Again, he was the one I would say, if I was the defense lawyer, I would have put him on, because he really does do a lot to explain the Vietnam trip. He makes it look like it was his decision on the visas, his decision on the flights.
Recommendation. He said, I didn't make any decisions, but I made recommendations.
All right, his recommendations on the flight. He looked on the fact that they were cheaper doing one way than round trip. He did a lot of stuff. He talked about, again, we would think, myself, Vietnam would not be a place I would think of to go on a vacation. But then he talked about how beautiful it was and how great the food was and how he'd been there multiple times. I think he was a witness I would have put on, and he gave them some decent facts for arguments about Vietnam.
Yeah, he's not like a witness that's going to win the case for you, but
No.
he is a witness that at least if the jury believes him, now there's at least some understanding as to why they may have picked a one-way ticket. It wasn't
Right.
because they were fleeing, it's because he said it's a little cheaper. And Mr. I'm in my gourmet club and I've been to 75 different countries around the world. I do believe, even if you want to say, oh, that's, rich people problems, whatever, I do believe he also is looking to save a couple pennies if he can get a one-way ticket cheaper than a round trip. So it's like, he's like, well, feels like one of those guys who I can tell, I can feel like I kind of do believe that. I do buy it. Again, I don't know how important it was as the overall case goes, but I do think it was helpful in poking some holes in the Vietnam flight that I believe is very damning evidence and is exactly what it seems to be, that Don Adelson was trying to get out of town to a non-extradition country. And there are other reasons why I believe that based on the other facts and evidence. But if you have a witness willing to say this and saying that this is true and this is actually how it went down, you got to call him as a defense. And
Yeah.
I think that he at least checked that box for them.
Yeah, absolutely. All right. And then next, after him, we've
There were
got
two
the
private investigators.
right talking about the snitches.
Mhm.
And I'm not so sure that these were very significant either, because these snitches actually testified, and just the fact that they were interviewed, talked, and they didn't say all these things. But what's key with these investigators was they went there, and these witnesses were not on the state witness list. And that was really important because that absolutely proved the only way that they would know about these two witnesses was because Donna Adelson told her lawyers, and her lawyers sent the investigators. So why would the lawyers send the investigators there to talk to them? Why would Donna talk about them? Because Donna told the investigators, these guys are going to exonerate me, and go ahead and do the interviews. So I think that was the timing of when they were interviewed and the fact they were not put on witness list was very important.
And the defense did a big fight to make sure that everybody knew. And I think there was a stipulation in the case that these witnesses were also never on the defense's witness list. And it's like, okay, so I guess you didn't end up using them, but what does that actually prove? Not much. Number one. Number two, this is a perfect example of what I said earlier, that it felt like the defense was just calling witnesses to call witnesses, because every point they got with these witnesses, I thought the male defense attorney, Mr. Zellman, I thought he got all these points out on cross with the jailhouse snitches, that they're obviously not reliable, that they told different investigators different things, that they didn't even remember who they told what. And when they told the first time part of the story, it didn't include these details in it that were bad for Donna Adelson. So I thought he already got all that out on cross, and it was totally unnecessary to call these two witnesses. But I felt, and also it didn't look good to me. Like, as a lawyer, I get why he said, don't record the witnesses, or the lawyer said, don't record these interviews and things like that. I get that as a lawyer. I get that's how we do it. But as far as it goes with a layperson and a juror, to hear that the defense lawyer wanted you to go interview this witness at the jailhouse and specifically told you not to record it, I think some jurors are probably going to be like, yeah, that sounds shady. Because I know we say it sometimes when cops don't do that. So as far as a juror thinks, like, what's the difference? You're sending an investigator. Why didn't he just record the interview? We could have played it here and all of us listened to it together. So it sounds kind of shady. And that didn't come out in the cross-examination of the jailhouse snitches, but it did come out when you call the investigators and the state gets the opportunity to cross-examine them.
Right. Yeah, there was no reason to call them. You were right. Everything that the defense could get out on, they got out on cross when they crossed the snitches. There was no reason to put these on. No, I agree.
All right. The next witness was Detective Turner, who played the video of Don Adelson, sitting and talking to the snitches with the notebook and the pen, and who's writing and who looks like they're controlling the conversation. That was the point. They played a long part of this video.
But it was nobody argued that it wasn't Donna Adelson's handwriting.
After the state called that expert, and the defense was like, we've never argued this was not her handwriting. It's
right.
Like, so what are we trying to do here? I don't get it.
Yeah. So, I mean, she wrote it. I don't know. Again, I don't know what value they put into that, but I think that they wasted some time.
I think they're trying to make it seem like, these people are all against Donna and they saw a get out of jail free card because she's a famous, defendant. But it's like, okay, but if she didn't talk to these witnesses, how would they ever have these details? That didn't make sense either. And she literally physically wrote out what she wanted them to say. Even if it was the truth, that doesn't look good, right? I mean, literally, even if that's the truth, we would never write out what a witness needs to say. That's not how things are done.
And the way, and we'll get to this, but we'll get to the way it was handled in closing. And I think that was really important, the way that this was handled in closing. But anyway, we'll wait till we get there.
I read all sorts of stuff online about seafood, so I always worry about what I'm putting in my body from a nutrition standpoint, but also taste, especially when you're talking about seafood. So I was really pumped when Wild Alaskan Company reached out to sponsor this channel because I had already used them in the past, and they are far and away the best wild-caught, perfectly portioned, nutrient-based seafood delivered directly to your door. Trust me, you haven't tasted fish this good. My family absolutely loves salmon, and we've swung and missed on a couple of the pieces we've bought and cooked in the past, which is what prompted me to do that research online and find Wild Alaskan. Wild caught versus farmed is important because it means that there are no antibiotics, GMOs, or additives. And one of the best parts, you can try it risk-free. 100% money-back guarantee. If you're not completely satisfied with your first box, Wild Alaskan Company will give you a full refund, no questions asked. Not all fish are the same. Get seafood you can trust. Go to wildalaskan.com/lawyer for $35 off your first box of premium wild-caught seafood. That's wildalaskan.com/lawyer for $35 off your first order. Thanks to Wild Alaskan Company for sponsoring this episode. All right, let's now get into the second day of the defense.
They had one more witness that was going to work. The realtor from Tallahassee saying that Donna and Harvey were looking for houses in Tallahassee. Another waste of time.
Nothing burger, but I do want to bring up the sequestration issue. So that witness accidentally sits in the courtroom, wasn't supposed to. Another expert that we're going to hear about when we talk about the next day sits in and listens to testimony without the judge saying it's okay. And there was confusion about whether the prosecutors agreed to it. The defense clearly asked for it. What did you think about the defense's, first off, how many breaks they had to take before cross-examining witnesses, how many times they had to send the jury out, and it was so obvious because they needed more time to prepare. Even when they did that, when the jury came in, they're moving podiums around and doing all this stuff to where it's like, I thought we just took a break so you'd be ready. And then these sequestration issues that happened, somewhat in front of the jury because they had to deal with it with certain questions and the judge had to give certain instructions, some of it outside the presence of the jury. What was your thought about that?
Well, I can say that again, a lot of trials. My sequestration problems only happened when I was a first year lawyer trying cases. After that, I made sure that my witnesses knew they couldn't sit in on the trial. I made sure they understand sequestration. And I always looked in the back periodically, just for, I guess, habit, to see if any of my witnesses were sitting back there. I can tell you who was sharp and who was impressive: the bailiffs. Did you notice that the bailiffs knew who the witnesses were and actually told the judge how many minutes the witness had been sitting in the back of the courtroom? I got to give those guys credit. I mean, these are good bailiffs.
Yeah, I agree. And while neither of them necessarily was overly prejudicial, it is just a little embarrassing as far as being a defense lawyer and having that happen, because I'll give them a little grace because the courtrooms are packed and it's high profile and there's a lot going on. So I get how a realtor in a suit that looks like everybody else that's sitting in the gallery, how you might miss something like that. But it's not like, it shouldn't be the first time you meet or see somebody. This has to be part of the preparation. Like, hey, you cannot watch. Like, I would have asked, if I was the state, I would have asked that realtor, have you been watching this online? Like, you were interested enough to come sit in the courtroom and watch this trial. Have you been watching it for the days preceding online because you're interested, because you're going to be a witness in this trial? Because my guess would have been, if he didn't know he couldn't come sit in the courtroom, he's probably been watching online too, which is an issue. And that's something the lawyer has to prepare their own witnesses for. And while, again, I don't think it's a huge prejudicial problem or material issue in the trial, it is embarrassing. It shouldn't happen. And we don't really see it happen that often, especially twice in one trial.
No, we don't. And aren't you supposed to keep your witnesses? Don't you know who your witnesses are? And are they there ready to be called into the courtroom? And they had an extra person at their table that should have been keeping track of the witnesses.
They had paralegals and staff there with them too.
Right. That should have been keeping track of your witnesses. Okay, who's here? Who's out in the hallway? Who's ready to come in to testify? That's what those staff people are supposed to be doing. And they weren't doing it. So, it does show disorganization. It does.
Yeah, it's not great. It's not great. Okay, so then we get to the next day where we get to the Wendy Adelson's lawyer and then the expert lawyer, and their defense and argument is this really wasn't that bad of a divorce. It was pretty amicable. It was quick. It was cheap. It was easy. No big deal. Everybody was hugs and kisses around this divorce table. So we don't understand why they're making it such a big motive in this case.
Well, why do you put on witnesses for issues you can't win? This is an issue they cannot win. You cannot win that this was not a contentious divorce. It is their motive. It is the reason for the M. So why do you put that on? Why is it? Now, there were some things that they could have done with this witness that I think that were beneficial, and that things are like timing. When we had the order for no relocation, those kinds of things, those were important. How much space there was between those things. But to sit there and argue that it wasn't contentious and then put on the very evidence showing it was contentious, it was a loser. And I don't understand why you put losers on, but they put a dead bang loser on rather than just using her for the things that might benefit their arguments. Then again, asking her opinions just didn't make sense.
It was so, and again, talk about something that just completely swings and misses with a jury. Oh, it's only $80,000. Oh, this was only $30,000. Oh, we have so much worse divorces. I've seen this happen before, sure, where people hurt themselves or hurt somebody else. I was like, what? Like, no. And I mean, a pristine point made on cross and in closing. It's like, don't you think this is a little different for you and I as lawyers looking at this versus how the clients live it as their only case and the most important thing in their lives? I agree with you. There were some points to be made. Like, even if you wanted to go as far as for Wendy's lawyer to say, yeah, Donna was there. She was sad, but she wasn't overly upset. She was perfectly fine after the no relocation. She understood that's how it goes. And I explained to them that was the likely result. So yes, she's pissed off. She's calling him names, but she wasn't like, that's it. We're going to go get Dan Markell now. She never said anything like that. If you want to say things like that, yes, she was mad. Yes, it was heated. Yes, that's normal in divorce cases, but people don't usually take these extreme measures. And I don't think Donna had anything to do with this. If you want to say something like that based on, Donna's feelings and how she was acting, that's fine. But to act like this was no big deal, nobody really cared about this, is just, it's illogical. And it's the defense asking the jury to disregard and discredit their own eyes, ears, and their own common sense, which never goes well when you ask a jury to do that.
And by this time, they'd already seen all those text messages, and they'd already seen all the evidence the state was going to put on. And it's hard to say, one thing, and then you've got these text messages which are absolute fact, and they are out of the mouth of Donna Adelson. So there was some good and some bad you could have done, but they did a lot of bad. And I think the jury also. These jurors are everyday people. They all know people who've been through divorces. They all know people that know that this is not unusual. This is not something to think, oh gosh, this is shocking that this divorce is contentious. As far as I know, just about every once in a while you get one that's not, but generally speaking, divorces that are contentious. And so this was no surprise, and they should have just relied on the fact that common man knows that divorces can be contentious. And that's what happened, especially with children.
Yeah, to me, that's just a total swing and a miss. And in jury selection, some of the jurors were saying like, yeah, my divorce was handled in 3 days. Yeah, it was amicable. A bunch of them had amicable divorces. My guess is it didn't look anything like this. No. And that's the problem for the defense.
And another problem they had with her was the grandmother motion. The fact that they talked about she said that that only she and Wendy dealt with the grandmother motion. And as far as she knew, the grandmother didn't know about the grandmother motion. Well, we know from the messages that that Donna was significantly involved in that grandmother motion and knew all about it. So why would you have a witness testify to something that is absolutely proven to be not a fact? Again, why do you do that? It's a loser. Leave it alone. Go somewhere else with your questions.
Yeah. I just thought it was kind of a weird move for the defense too, to call a family law expert to come and say like, yeah, I'm an
Yeah.
expert and this was not a big deal. It's
You're
like,
talking about Bailey,
okay.
the expert they called
Yeah.
right after.
Yeah.
And what do you call it? You call a classmate and someone who's a good friend and obviously absolutely loves the divorce lawyer who handles this case. So total prejudice, total bias, and again, a total waste of time because all she did was repeat the stuff that the Adamson, I guess his name, said.
Adelson. Oh,
Adelson, no,
Adamson. You're talking about the
Adamson.
lawyer.
Yes, that Adamson said.
Wendy's lawyer.
Right, Wendy's lawyer. It was, again, another total waste of time. I don't know why they did it. There was a good cross on it. By the way, I thought she did a good cross on her. And she showed a little emotion in that cross, but I like the emotion she showed because
a lot of emotion.
Because it got to her finally that they were doing all this stuff. And it was a total contradiction to all of the evidence in the case.
Yeah, I think that type of shock and awe and emotion and like you're offended by how this person is testifying, it works as long as the jury's with you. If the jury's not with you, does that rub them the wrong way? But in this case, the jury was with the prosecution the entire time. I think that was obvious. And that's what I've been saying the whole time with this story is the story is so good that I think they could convict just about anybody they want to that's on any of these text chains. We'll save what you think about that until a little bit later in the discussion. Also, there's some discussion about Donna testifying. I want to hold that and knock out the couple witnesses before we get to Donna testifying. So trying to think.
The attorney, her attorney was.
Oh yeah, that's right. That's right.
Was next.
What did you think about that? So her criminal lawyer.
Right. She waived the attorney-client privilege so that the attorney could testify to a particular issue because otherwise the attorney couldn't testify to it. And the issue was knowing whether or not there was a warrant out for her. I think this backfired.
100%.
Yes. I think that this was damaging to them because the impression I got up until this point was that no warrant, the call, all the information from the prosecutor came right before they made their reservation to Vietnam, so that they knew they could go to Vietnam. It turns out the call was before Charlie's verdict, and that it was well in advance of this Vietnam trip. And it was a call saying that there's no guarantee about self-surrender, and at the time there's no warrant. So it totally backfired on them. The timing is totally different than the impression they left the jury as of the call.
Not only is the timing totally different, but the way the snippets have come out about my lawyer told me I was fine and that I could go and that the state would tell them if there was a warrant. Like I assumed all that was true because we've had those conversations before. But then this lawyer comes and testifies that no. I assumed that they would contact me before there was a warrant. I knew that there was no guarantee of self-surrender in this case. And then on cross, they're like, well, if somebody's about to flee, as a lawyer, that change in circumstances, usually they're not going to let you self-surrender. Usually they might not tell the defense lawyer, hey, there's a warrant issued when we have evidence to believe they're about to get on a one-way plane to a non-extradition country and never come back. That can change circumstances, right? And the lawyer's like, I know it can change what I argue in a bond hearing if the judge finds out that information because I'm a lawyer. I'm not a cop. This lawyer protected herself and answered honestly, but it was not good for Donna Adelson. It really was.
No, and it made the defense look like they had misled the jury. I think. Go ahead.
It seemed better before. Like what was in the jury's mind and mine watching this, my picture of what happened was much better before this witness took the stand.
Right.
All right. The last witness then was the victim advocate who basically testified that Donna was appropriately shocked when she found out. I thought that was a good point. I thought this was a quick witness, but she at least made a point for the defense.
Right.
What did you think? Anything more than that?
No, nothing more than that. That was it.
All right. So here's the big question I have for you. There were multiple conversations about Donna Adelson and whether or not she was going to testify. This defense team was clearly behind the eight ball. We've talked about it multiple times. The prosecutor tried this case 4 times. Donna thought she was going to have the same lawyer that Charlie had, who had already tried this case once, who was very prepared and ready to go, had the private investigators, had the theory of the case. She loses him. She loses the lawyers that she brought on to work with him. She has to find a new team. They have much less time to prepare for this humongous monster of a case with all these recorded phone calls. I mean, this was a very a large case, a large conspiracy with a lot of moving parts. Her lawyers were not nearly as prepared as the prosecutors in this case. They were clearly trying to catch up, and a trial is a living, breathing thing. It's very fluid. There's a lot going on every single day. They wanted more time to talk to Donna Adelson. And we were about 3 o'clock on Wednesday, I believe. Is that right? Yeah, 3 o'clock on Wednesday. They wanted more time to talk to Donna Adelson. And the judge said, no, you've had plenty of time. We broke early yesterday. You can have 5 minutes to talk to Donna Adelson, but I need her decision now. She's in a position every criminal defendant is in, every criminal case. I want her decision now. No more time to wait. What did you think about that whole colloquy, dialogue, back and forth exchange? Do you think the judge made the right call?
I think the judge made the right call. I think he made a good record for the call. The only new witness was Rob and the two jailhouse informants from Charlie's trial, that she watched Charlie's trial, that she had full disclosure from the state attorney's office, that, again, they broke the day before early. And we all know, and I can tell you how we do it. I think everybody does it the same way. You have these discussions before the trial starts. You tell them they're going to have to make that decision, and you tell them that at some point they're going to have to make the decision. It doesn't have to be made before the trial starts because, like you said, a trial is a living, breathing thing. Things happen during trial that can change your opinion, but it's a decision you have to be prepared to make when the time comes to make it. So I don't think the judge did the wrong thing here. I think the judge gave them plenty of warning that she was going to have to make that decision. I think he even said it the day before.
He did not say the day before. He did not. He assumed that they talked about it the day before. He told them they were going to have to make this decision, but they broke in the middle of their case in chief when they had 5 more witnesses to call. I know you can say this, like you can say you think that he made the right call. Everybody's going to love it and agree with you in the chat because everybody hates Don Adelson. Dead wrong decision, in my opinion. This will be the single biggest appellate issue. And I think if you were doing this appeal, this would be the number one thing you did. He gave her 5 minutes, would not let her talk to her lawyers, both of whom said they didn't have enough time to fully go through everything with Don Adelson, and they needed to speak to her again. She's a 75-year-old witness who was about to be forced on the stand at 3:15 on a Wednesday after having her entire case in chief that day and not giving her till the morning to potentially start fresh, to testify, to talk about it one more night. An hour and a half of court time basically is what they were, quote unquote, wasting to give her the opportunity to discuss it further with her lawyers. I think they're going to have a pretty good argument that she felt pressured or coerced by the judge to force her decision when she just needed a little bit more time that would not have been prejudicial at all to the state, to let them wait until a Thursday morning, by the way. Thursday morning. It's not like this was Friday night. It's not like she was asking for a weekend. It's not like this was going to extend the trial a number of days. To me, this was pretty simple. He should have let her have until the morning, and he didn't. And I think that's going to be the single biggest appellate issue.
I agree that I would have that as an appellate issue. I agree that I would argue it just like you're arguing it. I'm not so sure it wasn't the right decision. And so, but yes, I will argue it. It's the issue I'd argue now. I do have to say it is a particularly sensitive appellate issue because appellate courts look at this a lot more than they look at evidentiary rulings. Evidentiary rulings, there's a lot of presumptions there in favor of the judge. On this one, they're going to look at it in the light toward the defense because a defendant testifying is such a big constitutional issue and such a Fifth Amendment waiver that it calls for greater scrutiny than just an evidentiary ruling. So yes, this will be scrutinized a lot closer than an evidentiary ruling.
Yeah, then like letting the jailhouse snitch testify. Like that's a discretion. The defense can, pound the table and say the judge made the wrong call. That's never going to end up overturning anything. But they mentioned multiple times leading up to this trial that she was going to testify. Charlie Adelson testified. I think they set up this defense in a way that made it necessary that she testify. I thought there was maybe there's a 0.001% chance they win if she does testify, but a 0% chance that they win if she doesn't testify. I tweeted about it. I said, it's basically like they're giving up. It's over. The problem is, here's the problem, and this is just the problem with this defense. They should have said, they wanted, quote unquote, more time. To me, and the judge had given them warnings throughout the day before, like you said, and other days where he said she's going to have to make this decision. But if they would have just made a better argument clearer that they just wanted till the morning. That judge, it's only an hour and a half. We can talk about jury instructions. Judge, she's 75 years old. I don't know exactly how old she is, but she's 75 years old. She's tired. It's been a long day. She's exhausted. It's been a 2-week trial. Let her rest and come fresh, ready in the morning to testify or make the decision not to testify. I think if they would have, because we've literally made that argument, you and I, and we have never lost that argument ever. Have we heard a judge say, no, you cannot do that? Can you think of a single time you've ever had a judge say, no, you cannot do that?
No, I can't.
That's what I'm saying.
I've never had a judge do what he did.
That's what I'm saying.
I never have, but I don't necessarily know an appellate court is going to say she didn't have.
I agree with you. I'm not saying, no, hold on. Just to be clear, I'm not saying she's going to win that appeal at all. I'm not saying she's going to win it. I just think that's her best argument. And when we have situations like this where you and I can look at each other and be like, yeah, we've never lost that argument before. And they just lost it pretty handily. Like the judge was not, he didn't even give him an hour. Like he was like 5 minutes and come back and do this. And I get why he's annoyed and I get why he thinks that they're unprepared. And I agree with him that they're unprepared, but this is why it's the same thing with the sequestration arguments. We both know. Were you at all surprised that even though they clearly violated the rule of sequestration, the judge let those 2 witnesses testify? Were you surprised?
No, because he didn't want to create an appellate issue because, you refuse to have a defense witness testify. You prevent a defense witness from testifying. A lot of times that gets reversed. So, you err on the side of caution and let the defense put their defense on.
And it's the expert, right? Their family law expert. If you would have struck that witness, that's a big deal. It wouldn't have mattered for the case really, but that's a big deal. And again, if she was asking for a full 24 hours or for a week or something like that, the timing, it was like 3:00 on a Wednesday. To me, that's not a huge ask for the judge. I think that's going to be, I'm glad we disagreed. That was probably fun for people to listen to. We see it a little bit differently, but I still feel like I proved my point. And I know for 100% fact how you would handle it as a lawyer. And you would lose your mind if this happened. Like you would just absolutely lose your mind if this happened. And they were discussing whether or not she could change her mind. So the defense closes their case in chief. They send the jury home early. They go through jury instructions. And there were some rumblings that maybe she was going to change her mind and ask to testify. Have you ever had a situation where one side or the other reopens their case in chief to either call a witness or to add evidence that they forgot to put in or whatever, where the court would allow them to reopen the case to put something in as long as, the other side hadn't started their case or anything like that?
Yes. That's happened a couple of times. And it's been, frankly, it's no problem. It's happened a couple of times and judges haven't really sweated a lot over it.
Exactly. Now, the state could have said, well, judge, we're not prepared now to cross her, but that wouldn't have really been true because they were prepared the night before. Why wouldn't they be prepared the next morning? But that would have been an interesting discussion. I don't think it happened. If it did, it could have happened at sidebar or something like that. If I was the defense and they did something like that, again, that adds to the appellate issue where if the judge said no, and they're like, judge, now she does want to testify, but again, she was probably a little bit worried about testifying because how do you answer some of these unanswerable questions? So maybe it didn't make a difference in the end, but I do think it's going to be quite an appellate issue. All right, let's move on now to closing arguments, starting with the state. What did you think were some of the highlights? Give your rating on the closing for the state.
All right. I think the state did a good closing argument. It seemed to me to be well organized. Just for something I want to throw out there, they waived lesser includeds on the first degree M. Mm-hmm. I thought that was interesting that they weren't going to do the lesser included offenses like second M or manslaughter, that they weren't going to do those. So both sides agreed to waive those. So all they went was first degree M and that was it. And I thought that was interesting in the jury instruction. I just throwing that out, but I
think that's because the defense was like, this is horrible what happened to him. And it was these 2 gang members that did it. They're the bad guys. So they're not going to argue for any of the lesser includeds. It was kind of always an all or nothing. I get what you're saying, but to me, it is what it is. That doesn't really surprise me much. All right. So I thought they did a good closing. They pointed out inconsistencies that from the opening statements to how they conducted some of the case with regards to whether or not Dan was a great guy or Dan was a real SOB. So they pointed that out. I thought the Spider-Man was a good, just for fun,
you throw something in there, and it's for fun. But I
Everybody
guarantee,
knows what that means too. Like
yeah,
people know
and
what
every
that means
juror,
without even saying anything. Yep.
and I guarantee every juror remembered that Spider-Man slide. I don't know if they have an in-house guy or they hired people, but they did a tremendous job with regards to their visual aids. Really,
Agreed.
really nice job. And they had to, because it was complicated. I think that one of the comments the prosecutor was, this is death by 1,000 cuts or something, but it was complicated because you had all these communications that you had to put into context and what they meant and how they went back and forth and how they talked in code. And so you had to point that out. I thought that it was a good strategy to point out Donna's vulgarities. I thought that really showed the difference between how some people may have tried to describe her to the jury and what the jury actually saw in her communications, in the way she talked and acted and conducted herself. So I thought that was good. The planner was particularly good, which, by the way, when we talk about the objection by the defense to not put in all of the planners or other planners in order to show things in context, and the judge denied their ability to put in any other pages of the planner but that one page. I thought that's an interesting issue when we're talking about issues. But the fact that she had the car license tag in her planner, those kinds of things, those are important parts. And there's no way for us to sit here and go through all of the cross references of all of the text messages and how the phone calls go from one to the other to the other to the other. I think that really was the nail in the coffin. The fact that these text messages were not just one time, but multiple times. It went from one to the other to the other. The one thing that I thought, I guess I didn't catch, and maybe you did catch it, was the call from Garcia to Harvey by mistake when Garcia thought he was calling Charlie. It didn't resonate with me that was the call that led them to Garcia, that they did not know about Garcia until they traced all of Harvey's phone calls. And that's how they found Garcia. I mean, maybe you realize that, but I didn't realize that was the kind of the linchpin that got them to Garcia, and the whole thing basically crumbled from there.
Yeah, I don't know if that's how they got to Garcia, but I know that's how they got the connection with Adelson's. I remember saying that the case was broken when they called the wrong Adelson. That's what somebody said. I think it might have been from like a news article or something, when they called the wrong Adelson.
That's what she said in closing. That was her closing, that Garcia to Harvey, and that's how they found Garcia. And then the TV code, which is really so obvious, but she emphasized that, and I thought that TV code was important. Adoptive admissions, that also was interesting, because during the course of the trial, the jury may or may not have picked up the fact that there are inconsistent defenses being presented. That she adopted the extortion defense when Charlie was being tried. And she said, yes, that's right, extortion.
The truth.
And then if you look at the script that she wrote for one of the jailhouse snitches, she emphasized extortion is what she wanted that jailhouse snitch to say about Kathy, and used the word extortion. I think it was written in capital letters even. So you've got this, this was extortion. Then you've got the defense, well, Charlie's innocent, that he really didn't commit a murder, that this is all a big mistake. So these are totally inconsistent defenses. And the fact that they're presenting those to the jury, and then the prosecutor clearly presented to the jury that these are inconsistent defenses, and you take a look at that, either it's extortion or they didn't do it. Which is it? And she certainly disproved the extortion part of it. So I thought that was a very important part of the closing. And then they talked about Rob. Rob's pretty key. I think you've said this before. He is one of the most credible witnesses that testified. And so using Rob was pretty important. And then Another thing, they didn't say this in their closing, but one of the things that we know that jurors aren't allowed to supposedly know are what the sentences are, or the possible sentences that people are supposed to get if they're convicted of the crime. In this case, we know the jury knows that this is life. We've had witnesses testify that they have life, that they've been convicted of this case. So in this case, we have an unusual circumstance of the jury knowing what the sentence is going to be. So again, I thought she did a good job. I thought that she covered everything pretty well. But without her visual aids, it could have been confusing. But she made it very clear, and the visual aids did a good job of, so the jury can have pictures in their minds rather than just her voice saying these things, because again, that could get confusing. So I thought she did a good job.
Yeah, I agree. Okay, what about the defense's closing?
Okay, well, the defense's closing, I thought her demeanor was a problem in the defense's closing.
I tend to agree. I listened to it on such fast speed that sometimes I don't get that, but she did seem to be like screaming and pounding the table a lot.
She was screaming at the jurors.
I pulled a couple of good points I thought that she did make, and decent, as good of arguments as you could have made as a defense team in this case. But overall demeanor sometimes makes it tough for the content to get through.
It's exactly, you're exactly right. It's exactly what I was going to say is the jurors might be so taken aback by her demeanor that they weren't really listening to the words that she was saying. And so I thought that her demeanor, she's pounding the table, she's yelling at them. Again, I'm a fairly aggressive lawyer, but when I'm talking to jurors, I want jurors not to think, I want them to think I'm your friend. I want them to like me. I don't care if witnesses like me. I don't care if the prosecutor likes me, but I sure want the jurors to like me. And screaming at them and pounding the table is not a way to get the jurors to like you. You're trying to make your client sympathetic. You've got again, we don't know, I forget her age, but she's at least 70-year-old, apparently, nice Jewish grandmother. Well, if you want to be a sympathetic client, you got to be sympathetic. So you've got to have the jurors have sympathy. Screaming at them is not the way to be sympathetic. And so, that really lost it. She also argued things, again, they presented in their defense, things that they're losers, that are absolute losers. And she continued to talk about those. It looks like she was trying to blame Wendy. I think that she really tried to put things on Wendy, saying that Wendy lied to her mother about relocation. That goes against all the evidence. I mean, really real evidence that they've got. The mother certainly knew about the relocation motion. There wasn't a lie going on. So I thought that was something that really shouldn't have done. She did make a good point about Charlie's and the fact that they canceled the insurance. That was one of the issues they talked about, that it was Charlie's insurance that could have been canceled. I thought that was a good point that she made. I think a big mistake was attacking Rob. Everybody, again, we all thought Rob was like the most credible witness, and she's attacking Rob. One thing she said that I think would have been her best argument, and she didn't keep it as a theme. She only said it once, as far as I could. She was a meddler, not a M. I thought that was a good phrase, a meddler. If they had used that strictly as their defense, if they had admitted that she was a meddler, I think they would have been better off in this closing argument if they'd have just pointed out she's just a meddler. How many people know grandmothers that are meddlers or mothers that are meddlers? That would have been a much better defense. Meddler, not a emmer.
Yeah. She said it was a real mistake for the state to call Rob. It's like, I'm not so sure that was a real mistake for them to call Rob. I think that was stupid. What did you think about her putting the list of names that Donna Adelson called Dan Markel and then proceeding to read each one of them out loud to the jury?
Why? I don't understand it. I don't get it either, especially since they talked about what a great guy Dan was. Again, these are loser arguments, and why she spent time on loser arguments. And then when they started she emphasized nothing that happens after after July, I think July 18th, after that, none of that matters. Yet she spent a ton of time talking about what happened after July 18th. Does going to Vietnam matter? That happened after July 18th. Does the fact that she wrote a script to a jailhouse snitch, does that matter, since that happened after July 18th? And then when they talked about that script, it wasn't a script. It was just a writing. They never really dealt with the script or what the script said. They never tried to explain it. They didn't try to give the jury some plausible explanation for that script. They just basically totally left it alone. Let's see. He didn't take much luggage to Vietnam. I mean, that was a fair point. You're leaving for the rest of your life theoretically, and you don't take a lot of luggage. So, I mean, Vietnam was a setup.
Oh gosh.
She argued that Vietnam was a setup, that the state had set her up to travel to Vietnam so that they could arrest her. Who could believe that? When they put on a witness talking about the fact that they set up the trip to Vietnam. I mean,
I literally, from my perspective, I wrote down in my notes, did they force her to Google non-extradition countries before she left? Did they force her to get a one-way ticket, not a round trip? Did they force her to get an emergency visa? Did they force her to get the 90-day visa versus the 30-day visa? Did they force her to have those conversations with Wendy? Like, that makes no sense. And Georgia Kaplan mentioned one of those, I think, like, did we force you to get a one-way ticket or something like that in the rebuttal, which I do want to talk about because I didn't talk about it on my video because we ended up getting a verdict. But that was such a stupid argument. I couldn't believe my ears when I heard that they forced her to go to Vietnam just so they could set her up. It's like, if only they could do that in every case, their job would be a lot easier.
I know. And then the way she closed it, there's not a single piece of evidence that she committed this crime. I mean, you don't say that because you've got to admit, as a defense lawyer, you've got to admit you're losers on there. Not losing the case, but certain areas that you have lost. There is some evidence, but you're trying to create reasonable doubt, which means there can be evidence of the crime, but there's a reasonable doubt that your client committed the crime. So, go ahead.
It's like it looks bad. We know it looks bad. We know it looks bad in this case because of the emails Donna Adelson wrote. But she's a meddler, not an M, right? She called him an a-hole. If every person that called somebody an a-hole killed him, like, we wouldn't have a society today. That doesn't mean she did that. And again, we're talking about like little points she made, right? A couple good little points on Vietnam. Also, I thought a good little point, like, they had a window to fix Wendy's TV. What if they would have come earlier? Then it's no longer an alibi. They offered the earlier time and she said yes. Well, that totally throws off them creating this alibi as a mastermind, matriarch, conspiracy, doing all of this. Those were some good little points that I think if they would have said, it's clear there's no evidence before this happened that she had any clue. When the bump happened, she thought Charlie was getting extorted at that point. She said nasty things about Dan. She never threatened him. Nobody ever heard her say that she wanted to take his life. She was in South Florida. Wendy was there. This is how all this happened. She was not involved. I know it looks bad, but just because it looks bad doesn't mean she did it. That's what you mean by just eating some of the problems and dealing with some of the problems, but really explaining how they still didn't prove she actually did it. Just because it looks bad, they didn't actually prove it happened.
All right. So I thought that ending was bad.
Yeah,
bad way to, because no juror, nobody anywhere is going to say that there was no evidence.
Right. I think her closing was better than her opening. But I really thought the opening was a struggle. So, but I do think the closing was a little better.
I'll agree with you. The closing was better than her opening.
Then we got to the rebuttal, which the state only saved 7 minutes out of 2 hours for the rebuttal, which I thought was a real mistake. And the prosecutor was incredibly rushed and sporadic and kind of all over the place. I thought she made some good points, but again, I thought a little bit of it got lost in delivery because it was a little bit flustered. And I think if she could go back, she'd probably leave about 20 minutes for rebuttal, and she could have absolutely hammered that defense closing. She made some really good points, But overall, that was kind of my thought about the rebuttal. What did you think?
Well, again, yes, absolutely rushed. And she talked fast, and she was getting through stuff really fast. But again, their visual aids saved them in the rebuttal. And when she put up the reasons why, you can say that Donna Adelson actually participated and was a principal in the M. But when she put that out, she put down the outside your house, the two of us set up the victim. Wendy told her not to give up even after she lost the relocation motion. Never give up. That just all the TVs, the extortion, all that stuff. She put a list up. She just went through the list. I think that was good because again, you had to get back to the fact they had to get back to Donna, and they had to get back to Donna and the M. Yes, they put on a whole bunch of evidence that an M occurred, but they had to put on how Donna directly was involved in the M, and that visual aid helped. They talked about the extortion, that Charlie either extorted or Charlie didn't do it, and they talked about the script, and because they didn't deal with the script in the defense closing argument, but they talked about the script. She was fast, but their visual aids, I think, saved them because the jurors, no matter what she was saying, and she was talking fast, the jurors was slowly reading the visual aid. So the jurors could read the visual aid even if they couldn't understand what she was saying because she was talking so fast.
Yeah, and I think her first close was good enough to where that gave all the jurors the ammunition. She even said stuff like, if some juror's back there and wants to acquit, ask them how this is not a confession. And that's the point of closing. Give the jurors the information they need to go back and argue for your side if they're with you and convince the other jurors to come with them on your side. And I thought
that was a good point. That's not a confession. I remember that I noted that too.
Yeah. All right, let's take a listen here to the verdict being read, and then we'll get your reaction to that. And specifically, so I want your reaction to what you thought when you first heard the verdict, and then what you think about the judge and how he handled Donna's outburst.
Reviewed the verdict form. It is in its proper order. At this time, I will publish the verdict. We, the jury, find as follows as the count one of the indictment, first-degree murder. The defendant is guilty of first-degree murder. Mrs. Adelson, control yourself. Count two, we, the jury, find as follows as the count two of the indictment, conspiracy to commit first-degree murder. The defendant is guilty of conspiracy to commit first-degree murder. Count three, we, the jury, find as follows as the count three of the indictment, solicitation to commit first-degree murder. The defendant is guilty of solicitation to commit first-degree murder. And it is signed and dated by the foreperson. One moment. Members of the jury, the bailiff will escort you to the jury room.
So he sends the jury out, and then I want to play, what he says to Donna after the jury leaves.
There will not be any. Mrs. Adelson, while this was not the outcome I'm sure that you desired, there will not be any further outbursts in front of the jury. If you cannot control yourself, I am going to have to determine if you will be removed from the remainder of this process. Do you understand what I'm saying to you? Yes. Do you need a moment to collect yourself?
All right. So first off, what did you think when you heard the verdict? A 3-hour deliberation, which is almost exactly the same as Charlie's.
Well, first off, a 3-hour verdict was a really, really quick verdict.
For this case, especially.
Yes. They had so much evidence to review, all those text messages, the timing, the cross-referencing, videos, tapes that were all put into evidence. That was a quick verdict. So, what else can I say? Quick verdict usually means guilty. So that was a quick verdict.
What did you think about oh, I'm assuming you weren't surprised, right? We thought this was going to go this way
No.
the whole time. What did you think about the judge keeping them there till like 8 o'clock at night?
Did he then? I got to ask you that because did he keep them or did he ask them if they wanted to stay?
I didn't hear anything about if there was any communication, but I know he had stayed. I think they stayed till like 6 o'clock one night. They had stayed past 5 o'clock multiple times. So it's not a surprise that this judge let them stay late. But as a defense attorney, would you have been like, Judge, can we break and go in the morning? Would you have wanted to set out like, here's the time court's going to end, or you just want to let it ride?
I would have made a motion because there is a case. There's a federal case called McLean where a judge kept a jury late. And the court said that that was unreasonable and that they're tired and, those kind of things. They actually reversed that case because the judge did that. Florida has a habit of keeping jurors late. They don't have any timetables in Florida. So, we're kind of a lot of states do have timetables as to how late a jurors can stay and how long a jury deliberations can go at night. We do not. So as long as there wasn't any complaints from the jurors, and usually, and this is I don't know, this judge has been so easygoing, low key kind of guy that my guess is he would have asked. My guess is the jurors wanted to stay, but again,
my guess is they realized.
Florida doesn't have any kind of rules.
Yeah, from my perspective, my guess is they were getting close, and he didn't make them stay. It was like 7 something. It wasn't like 10 o'clock at night. So I don't think it really waded into those waters where it would have been unreasonable. I just thought it was interesting. And, as a defense lawyer, if you are worried, or even if you want to make it look like it took longer and the jurors were struggling with it, sometimes lawyers will be like, can we stop and come back in the morning? And it wasn't a Friday night or anything like that. So there was no rush to it, but I don't think it was unreasonable at all. It's interesting. And these are what lawyers think about while this stuff is going on. What do we do? It's getting late. Do we want to try to bring something up? Could this be good for us? There's just so many things going on in a lawyer's head while the jury is deliberating. What did you think about how he handled her outburst? Ms. Adelson, control yourself. And then he sends the jury out and tells her, do you need a minute? Because I might have to kick you out of this courtroom if you can't control yourself. Well,
that's all a matter of style for a judge. Mm-hmm. Frankly, I've had verdicts. Unfortunately, every once in a while I did lose a case, and I've had, clients that have gotten very distraught, and the judge just basically acted like it, they weren't even there.
That seems to be a more common response to me. The judge just ignores the outburst.
Right, and so just kind of ignores it and just kind of rolls on, even though even though the client may faint. But the fact is that it's a matter of style, and this judge. His demeanor is, we just don't put up with anything like that. And therefore, I'm going to send the jury out and chastise you for that. But it's just his style. Again, I have never had a judge that kind of sent a jury out like that in the middle of the jury verdict. He gave the verdict, but he wasn't finished with them. But he sent them out. And I have never had that before. But again, matter of style, and certainly not an appellate issue.
And I've seen much worse outbursts, like much worse, screaming and, like you said, falling on the floor and knocking stuff over. So there's been much worse outbursts. But I would almost say about the judge, we both really enjoyed watching this judge through this whole trial, is he was doing that to both sides. Like if he would get frustrated with the prosecution, he would do it to them as well. Now, they definitely controlled the courtroom and there wasn't a lot of objections from the defense side, but he would say, stop if the defense was doing something. He would say stop if the prosecutor was doing something. So I feel like he was, in how he would chastise each side, he was pretty fair as far as that goes. But I do think you can also notice, and we've had this happen, and usually it's in our favor. He would take it as more credible if the state would say something in the defense. I kind of felt that throughout. Okay, so the last thing I want to touch on, actually, there's 2 things. First, we'll hit the prosecutor afterwards said, stay tuned. Do you think that means there are more charges coming? And do you think that means Wendy Adelson or Harvey Adelson is next?
Well, sadly, this is going to embolden the prosecutors. The fact that it was a 3-hour verdict, and they didn't have any smoking gun, so to speak, with regards to Donna Adelson. It's going to empower them, and I think that they're going to go back now and think that we got enough to convict anybody we want on this case. And I think it is more likely now than when I was talking earlier Earlier, after Wendy testified, I think I said that there just wasn't enough evidence there. I think the prosecutors think there is enough evidence, although I don't think so. I still don't. But I think the prosecutors are going to think there's enough evidence. If I was Wendy, I think I'd be getting ready. Harvey, I'm still not so sure. But if I was Wendy, I would think about getting ready.
Yeah, I definitely think Wendy is the big fish that they want to go. Harvey may or may not. He's just kind of there. But as far as Wendy goes, that's who they want. I feel exactly the same as I felt earlier. From what I've seen, there could be more evidence we don't know about, right? From what I've seen, it does not feel like there's enough evidence. But I've always felt like the story is too good. The story makes too much sense. And I think this prosecution team can convict Wendy. I think if they charge Wendy and they go to trial, I think they're going to win. And I think they're going to make the same. When you can say Sigfredo Garcia, convicted, prison for life. Luis Rivera took a deal. Katie McManawa, convicted, prison for life. Charlie, prison for life. Donna, prison for life. All for Wendy. This was for Wendy, and she's going to use the same defense as they did. I didn't know about it. They were doing it behind my back. That's what Donna Adelson tried. That's what Charlie tried. That's what everybody's tried, and it's failed. And when you can make those kind of arguments, it's pretty tough for a jury to be like, no, the one person who was actually married and getting a divorce and wanted to take the kids away, she didn't know about it. We're not going to convict her. I think the prosecution can win. It's just whether or not they should, which I'll leave it open to listening to the evidence, right? It's going to be a very different case against Wendy. And the other problem with the conspiracy is they're going to be able to get all these statements in of co-conspirators when in reality it's hearsay, somebody else saying it that Wendy has no clue they're even saying it. So I think that's a big evidentiary fight before it starts, is how many of Charlie and Donna's conversations are really going to come in for a trial against Wendy Adelson?
Well, I think a key in Wendy's case, and I really do, and I think we saw it, is who's her defense lawyer. I think that will make a huge difference in Wendy's case. A guy who fights, objects to everything, and doesn't let the state get away or slide by the rules of evidence. A really good defense lawyer will make that a different case. This one, I think even a good defense lawyer would have trouble winning the Donna's case. But I think a good defense lawyer can win Wendy's case.
I remember thinking through Charlie's trial that Donna's cooked. Like, Donna looks so bad in these emails and all these facts and on these tapes that even during Charlie's trial, I was like, it's over for Donna. Wendy, I have not felt like it's over for her as far as a chance to win. But again, the story is just fits into place. It's like a movie. All right. So to finish up, what did you think are potentially some of the big appellate issues that came out of this trial that either she'll argue, may be successful, may not, from Donna Adelson's perspective?
Well, I think the issue of how long she had to make a decision about whether she testifies or not. I frankly think that's the best appellate issue that I saw. Can you give me 1 second?
Sure.
Because I've got to go back, and because there weren't many. Then she will have I know they waived it, but the argument about whether or not you can, whether or not his lawyers were competent to waive the second degree M or the manslaughter and just stick with the first degree. I think that could be an appellate issue. That I said there weren't many. The undisclosed witnesses. You remember the defense was trying to say we couldn't subpoena this witness. We didn't have time to subpoena. We want the judge to, because she wouldn't talk to us, and we want the judge to inquire. And the judge said, "Look, if you didn't subpoena her, I don't have any jurisdiction. I can't do anything." The judge was wrong about that. That judge could have ordered that whoever that person is, the judge could have issued an order for that person to appear before them. So the judge was wrong that he had no way of getting jurisdiction over that witness. So I think that was a mistake. That's an issue that they could appeal, although they never listed these people as witnesses as well. So that's maybe a waiver. And those are the issues that I found. I mean, not much.
Yeah, I think there's probably a couple more, just how the trial went. I'm sure there's going to be an ineffective assistance of counsel claim. People don't realize, though, how low the bar is to actually be considered effective assistance. I told them about the case that we had. I remember you handled the appeal. I remember reading the transcripts, too, with you and doing some of the research. but the lawyers objected like one time in a 2-month trial. The defense lawyers literally objected one time. And it's like, that's ineffective assistance of counsel. So, I mean, the bar is unfortunately pretty low, but we'll see if that ends up becoming a claim. But so we talked about what we think is next. We talked about potential appellate issues. We will continue following to see if Wendy Adelson or Harvey Adelson ends up getting charged in this case and potentially tried. But I appreciate you coming on for only 2 weeks. It's a pretty short trial, only 2-week trial, giving us your thoughts on the defense's case, the verdict, and the aftermath. So that's all we got for this episode. I appreciate you guys tuning in. Would something else you want to say?
I just say it was a really interesting trial. I mean, I've got to say that it was interesting because, rarely do you get a situation where a whole family is involved like this. So I found it very interesting.
Yeah. And I think that from the perspective of the story and this being kind of your first really deep dive into it, watching this trials and not watching the other trials, it was kind of cool to have that perspective and see how that changes potentially if we get to Wendy's trial. You guys let us know in the comments who you think is next, Wendy, Harvey, or no one. And hit the like button. Make sure you're subscribed. Make sure you rate us on wherever you're listening to this as far as the podcast goes. But for this episode, that's all we got. Till next time, we are out of here. Thanks for watching another episode of The Lawyer You Know. If you enjoyed the episode, please hit the thumbs up and share with your friends who may be interested here on YouTube. And don't forget to subscribe. You can also follow us on Instagram, X, Facebook, and TikTok. And don't forget to check out the Lawyer You Know podcast featuring new episodes every week. And if you have a case that you want to personally talk to us about in your life, if it's a personal injury case, wrongful death, catastrophic injury, car accident, truck accident, or slip and fall case, please email us at lawyeryouknow@gmail.com. And of course, all these links I just mentioned are included in the description below on this episode and every episode. So until next time, this is Peter Tragos, The Lawyer You Know.